Good afternoon and welcome. We're pleased to have each of you with us today. We have 3 cases on the afternoon docket, and they will be called in the order in which they appear. Each side has a total of 15 minutes for argument, and that applies if you've got multiple attorneys. And the appellant has the right to reserve up to 5 of that 15 minutes. And so if you will let us know at the beginning of your argument how much time to reserve, we will program the clock accordingly. Are there any announcements? Hearing none, call the case, please.
Linda Black versus State of Tennessee.
Good afternoon, Ms. Martin.
Good afternoon, and deja vu.
Yeah,
I think I've been here before.
glad to have you back.
May it please the court. Good afternoon. I'm Sarah Martin, and I represent the claimant and appellant, Miss Linda Black, regarding the wrongful death of her husband of 42 years. And at this time, I'd like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
Yes, Your Honor. This court should reverse the Claims Commission's dismissal for 3 reasons. First, the commission made a prejudicial evidentiary error by allowing the defendant's expert witness and agent, Director of Nursing Sandra Wyatt Moore, to deny the authenticity of facility documents that had already been authenticated. Second, the commission conflated risk with inevitability regarding Mr. Black's UTI and dehydration. Third, several of the commission's findings lack support, especially given it relied heavily on opinions that were not to a reasonable degree of medical certainty. Under the Healthcare Liability Act, a claimant must prove the recognized standard of acceptable professional practice, or as I'll just refer to it, the standard of care, that the defendant acted below that standard, and that as a result, the claimant suffered injuries that he would have otherwise not suffered. Here is what the parties agree upon. First, Mr. Black was at risk for dehydration and UTIs. Second, the standard of care required staff to promptly recognize and appropriately respond to symptoms of infection. Third, the standard of care for Mr. Black required staff to notify the physician of significant changes in his status, like symptoms of infection. Fourth, that Mr. Black developed sepsis from a UTI that he contracted sometime between December 29th, 2016, when he tested negative, and January 8th, 2017, when he was hospitalized with septic shock. And finally, Your Honors, the UTI and the cascade of effects from it, including sepsis, and ultimately septic shock, hastened Mr. Black's decline and death. The contested issues at trial, therefore, were whether the defendant acted within the standard of care to prevent dehydration and UTI, and perhaps even more importantly, whether defendant promptly and appropriately recognized signs and symptoms of that UTI and dehydration. Turning to the first issue, which I'm going to lead with the evidentiary, which might seem strange because I know the standard of review is abuse of discretion, but it really colored the entire trial. One of this evidentiary dispute in particular concerned the facility's documentation policy. Under Rule 901 of the Rules of Evidence, something is authentic if there is evidence sufficient to support a finding that it is what the proponent says it is. In discovery, the claimant requested all of the facility's instructional materials on the proper care of Mr. Black or other residents during his residency. In response, the defendant produced documents that instructed staff to, first, document all services provided to the resident, any changes in the resident's medical or mental condition, and all observations, medications administered, and services performed. Document not just a change in the resident's status, but the notification of that change to the physician, and document something on every system during an assessment, even if it's normal. And these documents, again, were in response to a question about what the facility instructed staff upon regarding the proper way to care for residents during Mr. Black's residency. And during trial, or prior to trial, the parties stipulated that certain documents, including these, were authentic and admissible. And it's worth noting that under the Sixth Circuit rule concerning 901's federal counterpart, which is nearly identical, documents produced in discovery are self-authenticating admissions of a party opponent. So despite this stipulation and despite the federal policy, the Claims Commission permitted the defendant's director of nursing, Sandra Wyatt Moore, over objections of claimant's counsel, not only to deny the document's authenticity, but to argue that the facility's policy was exactly the opposite, and that was to chart by exception. Now, charting by exception means that you only document things that are not within normal limits.
Counsel, the state suggests that this is a matter of weight rather than authenticity. You obviously take the view that that's incorrect. Why is that incorrect in your view?
I do, Your Honor, because if this is an admission, then this evidence is direct evidence of what the facility believes the standard of care is. And that's because the regulation in the state of Tennessee on this matter, 1200-8-6-.04, subsection 13, requires that the facility's policies or its instructions to its staff be consistent with the standard of care. So essentially, Sandra Wyatt Moore was contradicting admissions of a party opponent and this document that had already been stipulated to as authentic, and she claimed that it was in fact not what the proponent argued that it was, and what her facility argued that it was or represented that it was in discovery. So the claimant's position is that it is an issue of undermining authenticity and not necessarily the weight. And further, Your Honor, the reason this evidence was significant to the claimant's case, specifically the fact that the facility staff were not properly monitoring Mr. Black's condition and reporting changes in his condition to the provider. And the reason we know that is because the facility told its staff they had to consistently document these things, and then they didn't do it. And despite that, Wyatt Moore was permitted to dispute the authenticity of those documents, saying that they weren't the facility's policy, and then put forth a completely different policy, contrary to what the facility had represented prior to trial. And this was trial by ambush. It was a prejudicial error, and it was abuse of discretion.
What material omission relates to an injury that the decedent suffered in the medical care context? What documentary omission affected Mr. Black's health and welfare?
Well, Your Honor, the most pivotal time in Mr. Black's timeline, from that 29th to the 8th, was the 6th, the 7th, and the 8th, when he was experiencing an obvious change in clinical status. He was unresponsive, he had high blood glucose, he had low blood pressure, he had a fast pulse, he had a high respiration rate, and he had a fever. And none of the experts disagree that those are signs of a systemic infection. But the first physician notification documented in the records of those symptoms was not until 9:40 p.m. on the 8th. And at that point in time, Dr. DeLaurentis ordered that staff call 911. That's how dire his condition was. But his condition had been dire for 2 days at that point. So that's the primary omission.
I go back to the policy, the documenting policy. And how does the documenting affect the notification of the physician? Aren't they two separate things? Aren't we really talking about should the healthcare facility have notified a physician earlier, as opposed to should the healthcare facility have documented more, if I'm making any sense?
I completely understand what you're trying to say, yes. The difference is this. The facility's position was that those things happened even though there was no documentation of it. The facility, specifically, there were notes about the Dr. DeLaurentis being notified about Mr. Black's high glucose. And that was expressly in the records. But it did not say notified physician of all these other concerning symptoms. So viewed in a vacuum, high glucose is just high glucose. But viewed in the context of all of these other concerning symptoms, Mr. Black very clearly had signs of a systemic infection. And the difference here is that the claimant's position is if it wasn't documented, it didn't happen. And the defendant's position is we assume our staff does what they're supposed to do even if they don't document it, because they have a professional license to be worried about, and because the facility's documentation policy, allegedly, was to chart by exception. So the assumption is, well, Mr. Black must have been fine during this time because there were no vital signs, or Mr. Black must have been fine during this time because staff didn't notice anything concerning and document it. And because the doctor was being notified of this glucose issue, ipso facto, she must have known about these other things too, even though it didn't clearly say so.
Counsel, in terms of the discovery disclosures here, the documents that were received with regard to the policy of documentation, were conflicting policies turned over? Did you receive in discovery policies that were consistent with what was ultimately testified to? And so I'm trying to figure out, did you get conflicting materials along the way, or was it only the policy that was ultimately inconsistent with what was testified to, that was disclosed during the discovery process?
The latter, Your Honor. The only policies and procedures or instructional materials that we received in discovery were indicated to us and to the claimant that the policy was to document everything. It was not until trial that we learned that the defendant's position was that they disputed that these policies even belonged to them, or that they followed them, or that they trained their staff on them.
Even though they turned them over to you
Correct, Your
in
Honor.
discovery.
Correct, Your Honor.
If the policy is document by exception, wouldn't some of the other things that Mr. Black was, his other symptoms, wouldn't they have been documented as well?
They should have been, and there was some documentation, but even Sandra Wyatt Moore admitted that there was no vital sheet at all in the chart, and there were sporadic vitals documented and sporadic assessments documented, but that they weren't documented consistently.
And so then the position is, well, if it's not documented, we assume they did it anyway because they're professionals.
Exactly, Your Honor.
Okay.
And I'd also like to address the fact that in addition to the lack of evidentiary support, because the other Dr. Boger, the defendant's expert, didn't testify to a degree of medical certainty, there's also the issue that the commission appears to have improperly conflated risk with inevitability. Mr. Black got a UTI because he was at risk for UTIs. Mr. Black was dehydrated because he's at risk for dehydration. Well, Your Honors, as both experts testified, all nursing home residents are at risk for UTIs, and all nursing home residents are at risk for dehydration. The facility still has to act within the standard of care to try and prevent those things from happening, and they did not do so here.
Also, does the state have to offer an alternative causation? And can't they simply challenge and say that you don't have enough proof that this was caused in the manner that your experts suggest?
Yes, Your Honor, I see I'm out of time, if I may. Specifically, they did not have to offer an alternative theory, but they did. They alleged that this was all related to dementia, but they didn't allege that it was inevitable. They didn't allege that this was a foregone conclusion, that they did everything they could and it still happened. And that's why care plans exist. It's why care plans need to be followed. And here, just in relation to the dehydration specifically, Mr. Black only met goal 1 out of the first 8 out of those 8 days in that 8-day period that we're talking about. Thank you, and I'll reserve my
All right,
time.
thank you. We'll hear from you on rebuttal. The state. Good afternoon.
May it please the court. My name is Tony Andolin, and I represent the state of Tennessee on behalf of the Tennessee State Veterans Home Clarksville, the appellee in this matter. Your Honors, this case arises from the unfortunate death of Robert Junios Black 16 days after his departure from his residency at the Tennessee State Veterans Home Clarksville and ultimate transfers to Tenova and St. Thomas hospitals. At trial, claimant identified but failed to prove that the state fell below the standard of care for 4 reasons. First, failure to follow the care plan for risk of dehydration. Second, failure to prevent the development of a urinary tract infection. Third, failure to notify the provider of a significant change in clinical status. And fourth, failure to properly assess the patient. As to each of these issues, the Claims Commission properly found that the standard of care was satisfied and that no action or omission on the part of the state caused Mr. Black's ultimate death. The Claims Commission further found that Dr. Boger, the state's expert, was more credible than Dr. Klein, the claimant's expert. This court should affirm the judgment below. The Claims Commission properly dismissed the claimant's healthcare liability claim. I will be addressing 2 main issues with you today. First, the Claims Commission's factual findings are presumed correct, and the appellant has failed to set forth any evidence in the record which preponderates against such findings. Second, the Claims Commission did not abuse its discretion in its evidentiary rulings. I'd like to first...
Let's start with the plaintiff's challenge to there being a lack of testimony based upon a reasonable degree of medical certainty. Can you address that challenge?
Yes, Your Honor. So Dr. Boger, which was the state's expert in this case, was properly disclosed. There was ample discovery made, and at trial, Dr. Boger testified, and claimant actually cross-examined Dr. Boger. There was no point...
But did he testify as to a reasonable degree of medical certainty concerning the standard of care?
So, Your Honor, the precise words "to a reasonable degree of medical certainty" were not used during that. However, most questions were prefaced with, "Dr. Boger, in your opinion," and the testimony that he gave was utilizing his skills and knowledge and experience as a medical expert.
Do you have any authority that you can cite that says we can substitute his opinion for a reasonable degree of medical certainty?
Your Honor, excuse me, I'm sorry. I am not familiar with that, but I would be happy to supplement a brief if the court would require it. But the state has not found any law in the state of Tennessee, nor has claimant cited any that shows that those specific words should be utilized in order to credit an expert's testimony. The Claims Commission never made any issue with that, nor did claimant even bring that up at trial. So the state would state that that argument would be waived. The first time we were hearing about it was on appeal. Addressing?
With the factual findings here from the commissioner, the commissioner references risk. There's a risk, right? And the patient comes in as at a heightened risk because of various medical issues that he has. In the factual findings the commissioner's making, is there a conflation going on of being at risk for something with causation of it? He has dementia, so he's at a higher risk. He has diabetes, so he's at a higher risk. Isn't that distinct from what actually causes the infection? Or maybe I'm just misunderstanding the facts on it, and maybe there's causation that's driven by that rather than some failure of care. What's the evidence there in terms of alternative causation for the sepsis that developed, or is there any?
So the claimant was required to prove the causation as part of her healthcare liability claim. And the state does cite to the Sackler opinion, or the claimant, I'm sorry, cites to the Sackler opinion in their briefing. And that the defendant or the state at this point wasn't required to prove an alternate theory. The burden of proof was on the claimant to show that the standard of care was breached and that the state caused Mr. Black's ultimate death. And
is the commissioner's order, though, treating risk as if it is a cause? And it's reading through it, it looks at times like that the risk is being understood as to being the cause of the infection rather than susceptibility to infection. Is that how the commissioner's written this in terms of the factual findings, or I may be mistaken on that? Is my understanding correct that the commissioner's maybe putting those two things together, risk and cause?
I would disagree, Your Honor, respectfully. I believe that the commissioner made certain findings and assessed certain weight to the evidence based on the testimony and the evidence at trial. The commissioner found Dr. Boger's testimony more credible, and it should go to show that the evidence in the record is very clear that Mr. Black was an 84-year-old man with several ailing symptoms. He had a previous history of UTIs. He had dysphagia. He had seizures. He was very ill, to the fact that the record even shows Dr. De Laurentiis, upon admission and for her full care assessment, addressed him as a 7C risk score, which allowed him to be eligible for hospice. This was end-of-life care. It's unfortunate that the conversations had with Ms. Black, the claimant of the deceased, they weren't on the same page. But yes, Mr. Black was more at risk for UTIs because he had diabetes. Mr. Black was more at risk for sepsis because he wasn't eating properly. The Tennessee State Veterans Home had even suggested he be on a modified diet. And Ms. Black waived that with the understanding, and this waiver is in the record, that he would be more at risk to aspirate, which could cause pneumonia, which was one of the causes of death.
Gentlemen, oh, sorry.
What do we do with the healthcare facility's failure to chart Mr. Black's medical status hour from hour, day from day? He's ill, he's old, he's infirm, but he's still entitled to quality care pursuant to the standard of care. And how can we determine if he got that care if there's no documentation or poor documentation?
Yes, Your Honor, and the state also disagrees with claimant's position on that. This facility was a brand-new facility within the state of Tennessee, and the record shows that they had 24-hour round-the-clock RN care for these patients, and the patients only were, by statute, only supposed to have 2.5 hours of care where they have direct patient care. This facility was doing between 10 and 11 hours of literally direct patient care.
And is that pursuant to the written standard of care policies or the ones that the witness said applies? Which standard do we follow?
The standard of care in the state of Tennessee is to chart by exception, which is what the Tennessee State Veterans Home did. And the
Well,
record,
is that what the state stipulated?
the state stipulated to certain documents being authentic and admissible. However, during trial, the Claims Commission had the opportunity to.
I'm gathering from your long answers that that's not what you want to defend the case on, that documentation.
No, Your Honor, those were merely and purely educational documents. Those were not the policies of the Tennessee State Veterans Home,
So that's not the standard of care?
Your Honor. And Nurse Wyatt Moore testified.
Then why does it even exist?
They were purely educational documents. During discovery,
Do you provide educational information for discovery on what's the standard of care for a patient?
Your Honor, the
This is not an educational exercise.
I
We're
understand.
trying to find out the standard of the care, and what I hear you saying is the state presented documentation that pretends to be the standard of care, but the state doesn't intend for it to be the standard of care.
Your Honor, the state never suggested that it was the standard of care. Those
Well,
documents.
then what was it titled?
One of the documents didn't even have a title, Your Honor.
Gentlemen, was it?
Well, in response to what question was it presented?
I'm sorry, Your Honor, can you please repeat the
You
question?
usually present documents in response to a request for production of documents or a question in a deposition.
Yes, Your Honor.
What was the question?
The question, request for production 24 stated, all films, videos, recordings, books, periodicals, materials, or other documentation that was provided by you or the training coordinator of the facility to any nursing personnel of said facility for purposes of demonstrating, describing, or instructing employees on the proper care of residents during the residency. So
All right.
that was very broad.
All right, yeah, but what I hear you saying is that's the information you provided to the staff for training, but that's not what you want the healthcare facility to be judged upon.
I understand your concern, Your Honor.
No,
and
it's not a concern, it's a question.
we would say that Nurse Wyatt Moore testified that they did not use those policies and implement those.
You train your employees to do this, but when you're judged on whether you're giving a proper standard of care, we're to disregard it.
It was not clear from the record whether or not the three policies and documents at issue were actually
Well, how is an
used.
employee supposed to know how to treat a patient if the information the facility gives them is inconsequential?
The testimony elicited at trial did show that proper training for the residents did occur, and Nurse Wyatt Moore credibly testified.
But these
and-
documents are not the proper training.
That's correct, Your Honor.
So you give the employees these documents as training information, but that's not the proper training.
The testimony wasn't clear at trial whether or not the documents were provided to each employee at the facility.
But you presented it to the plaintiff saying that this is what we provide to the employees for training.
Respectfully, Your Honor, we provided those documents based on a very broad discovery request, and claimant had the opportunity.
Why do the documents even exist
I'm not sure. Your-
if they're not to train the employees?
I am unsure of that answer, Your Honor.
Okay.
Briefly, I would just like to touch on the point by one moment, Your Honors.
You're sure, take your time.
Just one other point I'd like to make, Your Honor, is that Ms. Sandra Wyatt Moore was called by the claimant in this case, and here it appears that the claimant simply doesn't like what she had to say, which I understand the court's concern going back to the documents, but this court has held that any testimony elicited by a party's cross-examination of an opposing party or witness, they can't be heard to complain about that testimony. And again, just to recap, the claimant had a full and fair opportunity during discovery to question the state's witnesses regarding the documents that she now takes issue with.
General, the policy that was ultimately testified as to in this case in terms of how documentation was conducted, was that disclosed at any point to the plaintiff in this case? And so did they receive sort of conflicting policies in terms of what was turned over to them in discovery, or was the only policy they received one that had a different documentation approach than what was ultimately testified to in the proceedings before the commissioner here?
Those were the only policies that were provided.
Okay, so there was a written policy that was provided during discovery that was consistent with what the nurse supervisor ultimately testified to in this case in terms of how documentation is done in this facility.
No, Your Honor, the policies that are being taken issue with, they have said that they would write down every single thing. The standard of care at the facility was charting by exception, so it was different.
But that wasn't disclosed to the plaintiff at any point in discovery, that was the actual policy. They requested all of the documents for training, how do you do things. The state didn't send conflicting policies that then the plaintiff had to figure out, was this the old policy or the new policy? Instead, they only received one policy that had a different documentation approach than what was ultimately testified to at trial. Is that
That's
right?
correct,
Okay.
Your Honor.
You mean there's no written policy? That just struck me. It's a good question. There's no written policy that says you document by exception?
I believe it's statutory, Your Honor.
It's statutory. Okay. You don't know the
You
statute,
know the
do you?
statute.
I apologize. Can I see that another time?
Okay.
Why do you think it's statutory? I've never heard of a statute that deals with documenting by exception.
I'm definitely misspeaking right now. I believe it's part of the Board of Nursing's procedures and policies, but again, I would be happy to shortly brief that.
All right, thank you very much. All right, Ms. Martin, your rebuttal. At any time during the trial, did the state provide any written policies about chart by exception?
No, Your Honor. In fact, during trial, when claimant's counsel questioned Wyatt Moore about whether a written policy existed about charting by exception or whether she could point to any written policy, she said that she could not. And so that is definitive. It is on the record. And it wasn't that claimant's counsel simply didn't like what she had to say. It was that the state's position appeared to be that they provided documents that they shouldn't have provided if that wasn't their policy during the residency. And Rule 26 says if you recognize that you have made a mistake and that a disclosure was incorrect when you made it, you have a duty to correct that.
Seasonably supplement.
And the state never did that. And so the first time learning that they refuted those were their policies during Mr. Black's residency was on the stand at trial and Ms. Whitemore's testimony. And so essentially, Your Honor, I think, Judge Clement, I think you hit the nail on the head. The state wants you to believe that it is educating its staff to do something that it actually doesn't expect them to do. And that just simply doesn't make any sense. And further, Your Honor, regarding the reasonable degree of medical certainty, if you reread the order from the commission, it is very clear that over and over and over again, the commission was relying on Dr. Boger's testimony. Over and over and over again. The commission finds Dr. Boger's testimony more credible than Dr. Klein, over and over and over again. And claimant's counsel did not cite Sackler. We actually cited Hunter versus Ura, which cites to Sackler. And in Hunter versus Ura, these evidentiary rules require a trial court to determine whether expert testimony will assist the trier of fact and whether the facts and data underlying the testimony indicate a lack of trustworthiness. We weren't in front of a jury. So regarding things that are to the weight of the testimony, like this would have been, because as Your Honors know, there are very few reasons to foreclose testimony altogether, and they primarily deal with the locality rule. They do not deal with whether an opinion is given to a reasonable degree of medical certainty. That is a weight issue, and it very, very clearly appears that the commission accorded improper weight to Dr. Boger's testimony, given that lack of medical certainty. And lastly, Your Honor, I just want to read Dr. Boger's testimony. I know I'm going to run out of time if you'll just allow me to read this one little passage. Dr. Boger testified, but frankly, with how weak and debilitated he was before, this is not a guy that could handle that type of insult, meaning septic shock, and come out the other side. So he continued to decline afterwards, really, essentially was having a downward slope, and then that got accelerated with everything else and completed probably sooner than would have otherwise. And it's for all of these reasons that we ask you to reverse the commission's dismissal. Thank you.
Thank you. Thank you both for your arguments. We'll take this matter under advisement.